And that's effectively the bottom line. If you want to use or possess it, you have to grow it. You cannot buy it. You cannot sell it. Your only means is to grow it yourself. And you do need to grow it yourself. You can't have somebody else grow it for you. And if you are to use it, you must use it in private, and you can only use it yourself.
Are there disclaimers of what in private means? You know, is in private at the pool around the complex? Is it in my house? Is it in my estate?
The judgment is unfortunately less than clear on that, except to say that in private goes beyond being in one's private dwelling, so that the court, in talking about, for instance, the possession of it, if one were to possess marijuana by having it, say, in your pocket, and you were to leave your home with it in your pocket, it would still be within your private possession. That's about the greatest clarity that we have on privacy beyond one's home. There also seems to be lack of clarity on whether privacy necessarily extends to being within your home. Because if there are members of the public in your home, or friends even in your home, does that mean that your home is no longer private? It's unclear.
All right. Does it say whether or not you can share, now that we're on the issue of friends? So if you have friends coming over, do they have to bring their own homegrown marijuana, or can you give them some of yours?
I believe, on my reading of the judgment, that if you were to give them some of your own, you would be crossing the line into dealing, which is strictly prohibited. They would have to bring their own, which they grew for their own personal use.
All right. Well, it's